Y'all would bear with us. Let's see if we get any of our other committee members to come.
Ladies and gentlemen, come to order if you will, please. I'm Dale Washburn. I'm the chairman of the Regulated Industry Low THC Subcommittee, and we are having a hearing only today to hear a bill presented by Chairman Powell, which is House Bill 1400. And Mr. Chairman, we recognize you to present the bill.
Of the committee. I want to start out by prefacing some remarks, and I think everybody pretty well knows what this issue is about. And it goes back to a hearing, quite frankly, that was held back in November. And I think most everybody here was at that meeting, and that was an oversight to look to see what was the holdup on the issuance of licenses for the medical cannabis grow operations. And you may remember at that time, the director of the commission came forth, and it was absolutely the biggest waste of time that we've ever spent, probably, because he could not nor would not answer a question, because in his opinion that the law that was passed 3 years ago overwhelmingly stated that he couldn't reveal any information. So I took him at that, even though it gave me an awful lot of anxiety to know that a standing committee of the House of Representatives couldn't get an answer to a problem. And maybe that problem started 3 years ago with the drafting of the bill or the eventual processing of the bill as it went through the process and then to the Senate and then to the conference committee. But the bottom line that we have to look at is, why is the will of the General Assembly as passed 3 years ago, over 1,000 days ago, why has it took so much time to get this in operation? There were 69 applicants that applied for licensing. And out of the 69, pursuant to the code, that there were 6 that were tentatively awarded, not awarded, but tentatively awarded. And that was 2 class 1s. There was a 100,000 square foot facility, and 4 class 2s that were 50,000 square feet. But still, no licenses are issued and no production has been started. And in looking into that, it's interesting, and I continue to remind folks about transparency. There's a reason for transparency in most things in government, as it should be. Because after the meeting that was held back in November, the media had gotten involved. And as y'all, most of y'all know, I could be very plain spoken and very direct. And my comments brought forth a lot of the applicants who had duly filed a protest. And the protest was included into the legislation 3 years ago. And a lot of those protesters, 15 protesters and one that is still being negotiated because for some reason the commission said they didn't get their email, which has been documented. I understand that they did. So that would put it at possibly 16 protesters. Now, I will tell you that there was a lot of faults with this bill. One started with that issue of the transparency, the open records part of that, so that you couldn't get an answer. Part of the legislation wasn't just the failure to allow the open records, but also the failure to allow transparency in the bidding process. That anything that was ever asked, that was redacted to the point it looked like something that came out of the White House. That nothing was said, nothing could be ascertained as to the problems. So now we get along to the other problems. Oversight. In the original bill, the oversight was very minuscule to be appointed by the Speaker and Lieutenant Governor. In this bill, and I think that being a little bit of the background, that I'm going to go through a few more comments and then I'll go through the bill itself. But after a number of meetings over this, we've looked at this, and I've talked to several attorneys. Most of the attorneys and legal scholars that I have talked to have said that the protesters would be the only people who had standing out of the 69 applicants, 6 tentatively approved and 16 protesters, that the protesters are the only people that would have standing to file litigation. And I want you to keep that part in your mind when I say filing litigation. Because if you don't like the 3-year delay so far, you ain't going to like it whenever they start filing litigation. Because it's my understanding from the legal community that any litigation will be filed in the Fulton County Superior Courts, which is a timely process. And I've been told, everything from 12 months to 18 months possibly. Then you've got a period of time to go through the Court of Appeals and the Supreme Court. So that if there's any protest, if there's any litigation filed by a protester, then we're talking about possibly another 3 years of a downtime. And then the courts would step in and they would make the ruling. And what these protests would be based on, a description you need to remember, it's called the lack of due process of the evaluation of the applications. Now, I'm not an attorney. I may be the only one of the very few members of the legislature that tells you he's not an attorney. God knows we got plenty who think they are. So I rely on skilled attorneys, constitutionalists, and people who certainly do know better. And if I've been misinformed, then I stand that I was misinformed by professionals. The other folks who might have a opportunity to file a protest or to file litigation would be the 6 companies that have been tentatively selected by the commission. Now, the only thing that they would have reason to file would be if they were categorically dismissed after making a investment to go start forward. So there's the general issues at hand. So the question I've got is, where do we go to solve this problem? I will tell you, it's absolutely the most maddening fault of a process that I've ever seen. I can't blame anybody particularly, but I can say this is terrible, because y'all may remember that 3 years ago, that the General Assembly, for the biggest part, especially the House, after hearing testimony after testimony from people that had illnesses, children that had seizures, other people that had whatever malady, that it had been basically determined that cannabis oil would have a substantial benefit to those people. Or as I said at the time, that anything that I thought that God lets grow natural has got to be better than something produced in a chemical laboratory like Oxycontin or these other type drugs. So that's where we stand. And we stand at an issue today that if there's another way, and I have certainly told enough people, you got a better idea, they can get it done, then I'm all ears. But to this day, I haven't seen anything that's been proposed. So what we have got is a product in front of you today. It's narrowly focused. It's very direct, something to move this process along. And if you'll start with me on House Bill 1400, if you look at page 2324, what this does, this says that contracts will now be subject to the DOS procedures. You know, you're familiar with DOS, that's the state agency, and they have a specific number of procedures in place for dealing with contracts, applications, and such. So this basically says that at this point that the Cannabis Commission would be subject to DOS procedures. If you go down into section 2, one of the things that gave me anxiety was the fact that in 3 years' time, there'd only been questions asked, but no oversight. And I took a page out of existing law to set up that there would be two legislative oversight functions. One would be the House Regulated Industry Committee, which would be you gentlemen and the ladies that serve on regulated industries, and the Senate Regulated Industries Committee. This is similar to what we do with the Lottery Commission as far as legislative oversight, so that it would give the legislature very specific oversight into what they're doing. If you go to page 3 on the changes on lines 46 and the language on 47, 48, this would allow for more disclosure on contracts and applications to allow for transparency. This basically says that those contracts and applications and whatever, that what we have seen upon request, they came back all blacked out and redacted. This basically takes care of that issue. And remember, trade secrets are already covered in another section of Georgia law. We're not asking for anybody to reveal their trade secrets. If I want to know anything about the production of cannabis, then I'll call some of the good old boys up in the mountains that grow it up in the hoops and the hollers of Georgia mountains. But I don't know what it is. And then quite honestly, it's none of my business what a company's trade secrets or their models of operation would be. So that section allows more transparency of what's going on. Then you get down into section 3. And if you look at section 3, both on line 63 and on line 72, this increases the number of licensees from 2 to 9 on the class 1 and from 4 to 19 for the class 2. Now, that sounds like a lot, but remember on the 16 protesters, some of them applied for 1, some of them applied for a 2, some of them applied for 1 and a 2. So a lot of these numbers will not be reached because there'll be a maximum of 22 total. So there won't be, you can't get a class 1 and a class 2. And then again, at some point, I'm not too sure that a lot of these folks may back out, given the fact that if they haven't already received a tentative notice of production, then they may not carry forth, because remember in the original bill that these folks, once issued a license, they have 12 months to build, process, and have product on the shelf at the dispensaries. That's section 3 and 4. Section 5 is only, it changes the dates that the commission shall undertake a retrospective study of the participation of minorities and women-owned business as licensees. This moves that date from 22 to 1924. Section 6. This puts in that section from 103 down to 110. This makes the commission subject to the Administrative Procedures Act, something that is the standard of operation, that they have to answer questions. And this basically would make this commission and all of the operations subject to the Open Records Act and regulations. Section 7. This basically says that in future application process, that they will do so by having help to hire qualified third-party consultants. And then I'll get into that problem and why that's in there in just a second. You get down to 134, 135 and subsequent lines, that there will be no more than 22 total licenses issued. So you're going from 6 to 22. And quite honestly, and this is all about circumventing litigation. And that, gentlemen of the committee and ladies and gentlemen of the audience, is what that does. Now, for your reading pleasure, and I'll give you an example. This is one of the companies that came to me. And since they came to me, I don't think that they would mind. This was a company that's a protester, and it's a company called Georgia Sunrise Botanical. They and some other companies came to me when we couldn't get any answers to our questions back in November. And they brought me a copy of the sheet that lends credence to litigation to the lack of due process. I'd be glad to pass these around so you can see them, but we need to keep them together unless we can get them blown up somehow for the future. But the process that was allowed, as I understand it from this, was that if an application was submitted, the 6 commissioners that did not reach out or wasn't funded or whatever that issue may be for blind eye consultants to evaluate the applications. What was done at that point was that they took each of the applications and they took all of them and they divided them into categories. One category was called management experience for a maximum of 55 points. Second part was residency and tax filing requirements for a maximum of 45 points. This was 1/6 of the applications. Second part of the applications dealt with tier 1 and tier 2 job creation for a maximum of 50 points. A diversity plan, worth 75 point maximum. Businesses by minority enterprises for a maximum of 75 points. Staffing and employment plan for a maximum of 25 points. Labor and employment practices for a maximum of 25 points. This was the second part of the applications. Letters of support for a maximum of 25 points. Local government involvement for a maximum of 75 points. This was a third part of the application process. Space utilization plan for a maximum of 20 points. Production plan, 70 points. Product inventory and supply plan, 10 points. Product safety and quality plan, 125, maximum of 125 points. Product packaging plan, maximum of 25 points. That's the fourth section of the contracts. Tier 1, tier 2 job creation, diversity plan, 50 points, 75 points. Business by minority business enterprises, maximum of 75. Staffing and employment plans up to 25 points. Labor and employment practice up to 25 points. Fifth part. Tracking system plan, maximum of 100 points. Plan to ensure no pesticides, 25 up to 25 points. Safe disposal and incineration plan up to 25 points. Security plan up to 50 points. Transportation plan up to 50 points. Energy, water. Anyway, I think y'all are getting the gist of it. But each member of the commission evaluated only that fraction of the applications. And then they total the points, and that's how the points were awarded. Thus is the reason you had a lot of the folks that had applied that have said that there was a failure of due process of the application evaluation. Granted, I will tell you that a lot of the companies that didn't file a protest, quite frankly, a lot of those companies may have even had a better game plan or a better business model. But that's not what we're dealing with today, because what I am told from the attorneys and from DOAS is that the only folks that have standing would be the ones that actually went forth and filed a protest in this process. So I will tell you in my customary straightforward manner that y'all have heard me say before. I understand the politics of this. You know, originally 3 years ago, the issue at hand was to issue 12 licenses, and it got cut down to 6. And most of it got cut down across the hall when it went into through that process over there. It went back up, but that's basically what happened. It wasn't what was originally asked. It appears to me to give a little bit of sympathy, I guess is the best word, to this appointed commission, that they weren't given all the resources that they were needed, but yet they brought in an awful lot of money on the application fees and the such that was turned over to the general fund. But this was probably, in my mind, the worst of worst. I will say that I have told folks that the issuance of 22 licenses is not my, quite frankly, it's not my feeling that that's the best scenario. But this is the only way. And if it's, and this isn't one of those bills that I'm going to twist any elbows or any horns or anything else. This process is about the fact, do you think that the issue that we dealt with 3 years ago of helping sick people, children, adults, those folks that fall within those guidelines of approved diseases that have been added to over the last 3 years, by the way, do you think it's time that we have to do what's necessary to fix a broke system? Now, you can fix it either judicially or legislatively. If you want to let it go through the judicial process, then be prepared to hold on for another 3 years. If you want to fix it legislatively, this is the best idea that I have come up with. I have asked everyone from the governor to the senators over on the other side. I've asked members of the committee. I've talked to every possible person that had an interest in this. If you can give me an answer of another way of doing this, I'm all ears. But yet I haven't heard. I've had one that said, well, why don't we let the governor appoint? Why don't we let the governor choose one of the 6 that was pre-approved to go ahead and get started while they're working this out? Well, I tell you, that's another lawsuit waiting to happen because of the 6 applicants that were pre-approved, as well as the 16 protesters that weren't. Then that gives them all reason to file litigation. So then you're back to the same situation. Over in the Senate, I talked to someone over there of knowledge, and his idea was, well, let's just can the whole deal. Let's just void it and start all over. That's fine. But then you've got a situation that those people have already spent a lot of money acquiring land, building buildings, buying equipment. Then they have the possibility of litigation that we have then took what they have spent under a legislative and legal process. So, you know, we're almost damned if you do and damned if you don't. That's quite frankly how I look at it. 32 years, I've never run into a lot of scenarios of things. I don't think in 32 years, I don't think I've ever run into a scenario quite like this. And that's try to figure out a solution to make something work that was so popular, that's so needed for these folks that suffer conditions. So it's a judicial fix or legislative fix. That's up to each member of this committee, the full committee, and during the legislative process. What do they want? What do you want? Either way about it, we're going to wind up being sued and in the litigation. And then we'll be just like Florida. We'll be just like all the so many of the other states. And it's amazing to me how this thing had a pattern. No matter what state you talked about, it was all a pattern. Florida, that's twice the population size of Georgia, started, I believe, with 20 licenses or 22. They've now got 40 or 44, somewhere in that neighborhood, because the courts ruled it so. So are we to be hide from the issue of fixing it? Or do we allow the courts? And that decision rests with the members, the majority members of the legislature who vote in favor. I will tell you that I think there was probably close to 70 members who signed on to this bill. And I'm grateful to each and every one of them. And I'm sure there are naysayers out there who's got good ideas. But if you got a good idea about how to fix this process, bring them forth and let us look at them as we're going through the process. Mr. Chairman, I appreciate it. I'll stand ready to answer any questions today and to the meetings tomorrow. And I relinquish this to you.
Thank you, Mr. Chairman. Members of the committee, are there any questions of the chairman? Is that Chairman Jaspers?
There we go. Chairman Powell, you know, I'm first to acknowledge you have worked exceedingly hard on this ever since our meeting in November, like you said. And you've really taken the bull by the horns to find a solution. And I really respect and appreciate you for that. You know, just when you were talking a minute ago, this is a technical question. It's probably in some part of the other code, but I just want to, it just, you know, how I am about these little things. But you know, the scores went from whatever to 60 something for the lowest one. Was that something like that? I just want to make sure that the commission has the ability for that vendor, whoever the applicant that got a 62, has to change their procedures to get up to where it's satisfactory. Is that written in the other part, in the technical side of this bill, or is it, you know what I'm saying?
Mr. Chairman, I think that would fall under their operation as a commission.
Okay.
Which is one of the reasons that I want some solid oversight by a legislative committee. I can't answer to what a Senate regulated industries committee would do as oversight, but I can almost tell you what I think the House would do. When these licenses are issued and when the operation goes forward, then at that point, that commission is then responsible to have oversight through rule and regulation over how these companies operate. If a company is deemed to be deficient in some or any part of any of the parts of it, then they have the authority to bring forth changes or to force these changes. I also remember one of the things that this new oversight would do, if passed, this committee and the Senate committee would then have oversight to the rules and the regulations under the Administrative Procedures Act, so that when we ask a question, what are y'all people doing? They're going to have to give us an answer.
Yes, sir. I sure appreciate it.
No,
Thank
I
you, Mr.
appreciate
Chairman.
the question.
Representative Jackson.
Thank you, Chairman Powell. I want to call your attention to Section 3. As you were presenting supply and demand was just screaming out loud to me. So on line 63, and you provided some excellent, you expounded on the change, but I'm just curious, why only 9? And then on line 72, 19, because when you highlighted Florida, you said they started with 20 and now they're up to 40. It looks like there's a supply and demand in terms of capacity. How did you get to 9 and 19?
How we got to 9 and 19 is you got 16 protesters. And in this section, we're trying to deal with those protesters to circumvent any litigation that they could file. Some of these protesters, the 16, some of them filed for a class 1, some filed for a class 2. Some only filed for, I think it was only one of them that actually filed for a class 1. What this does, this gives the option to the commissioner. But those 16 that protested, they're only going to get one. If they applied for 1 and a 2, they're going to get only one of them. They'll get a 1 or a 2. So the possibilities are we could have as little as 3 class 1s, is the way I understand it. And the rest would be class 2s. But it'll have to be, that'll be the decision of this cannabis commission. That's the reason if you look further into the bill, it clearly states that there'll only be a maximum of 22 total.
Right. As a follow-up, so shouldn't we write House Bill 1400 to say, in Georgia, this is what the capacity is? Because it sounds like we're only addressing the 16. But what if that true number is has a greater capacity for Georgia? That's like saying we're only going to allow 20 Chick-fil-A's, and we know our capacity based on Georgia's agriculture, we can really provide more than just the numbers that's outlined in 63 and 72. Our agriculture, our industry can say that we really should have 40. Although 16 may be the issue today, but why not just grow to capacity, or at least have the capabilities thereof?
If I understand the point you're making, you're saying that maybe it needs to be more than the 22?
That's correct. Because
So
let's
you're
say,
actually saying let the free market determine.
absolutely.
Can I just say,
Excuse me.
welcome to the Republican Party?
Well, because I'm thinking that there's more than just, because you're only talking about the 16 for litigation purposes,
That's correct.
right? So what happens when there are more who learn that there's an opportunity in Georgia, and then they're going to file a lawsuit saying that
Out of the 40 some odd that applied per the law, there were only 16 that protested per law. And what we're told under the DOS procedures and the common practice, that if you did not file a protest by that assigned time, then you have lost your standing in law to file litigation.
All right, my last question is this. Line 92, when you start talking about license to minority and women-owned businesses, should we not increase that capacity as well?
Should we, I'm sorry, again, say
For
that.
lines 92 to 93 in section 5.
Can address that's in the current language. That's in the current litigation. I mean, the current legislation is passed 3 years ago. And if I understand, you're saying that probably that we need to increase more minority-owned businesses.
That's correct. That's the essence of my question.
Well, I'm not the one that needs to address that. But I remember the legislation is passed 3 years ago.
Yep.
That this bill was riddled with minority participation that was agreed to by the minority party at that time.
Okay, thank you.
24, Michael, Representative,
Thank you, Mr. Chairman.
Representative Smith.
Chairman Powell, is there anything that prohibits you all, when I say you all, the state of Georgia from issuing these licenses and then dealing with the people or the protesters later? Is there anything that prohibits that?
Filing of a lawsuit would do it.
Follow-up question, Mr. Chairman.
Sure, Representative.
What gives them, what affords the protesters the due process? What affords them that? Is it the legislation? Is it the process? What affords these protesters due process that's holding everything up?
I'm not sure that I understand. You're saying what gives them the right to?
What gives them the right to hold up this entire process?
Yeah,
And I know it's due
When
process.
the original bill was drafted, it set forth a protest period for any application, any applicant that did not feel that things were done on the square, fair, square and all.
So, Mr. Chairman, could we
It
fix
gave-
that legislatively and take that out?
Too late to take it out because it's already been processed. The bill was signed. And remember that we can't retroactively change legislation. Now, if you listen to some of the senators, they say, well, let's just void this whole law. Well, if you void it, you got 6 companies that have been tentatively approved that have spent a lot of money. I understand one down in South Georgia, one around Middle Georgia. And I mean, those are the only 2 because they're the folks that have come to me and when I talked to them because we couldn't get answers from the commission. But in talking to them, I understand that they've got several millions of dollars in the purchase of land, buildings, security equipment, whatever kind of equipment you put in these operations. So they're going to have to be satisfied. They in good faith spent money, filed an application, spent money in good faith once they were tentatively approved. So there you have an issue there. So we can't just arbitrarily change the law to say, we're sorry, take it in good faith, but we're going to pull back and whatever investments you've spent, you've lost.
Okay, Chairman Collins. Is that your line? I'm sorry, Representative Bennett.
Thank you. And thank you, Mr. Chairman. Just for clarification, so because 16 protesters file a protest, does that automatically give them, because we're increasing the total number of licensures to be given, does that mean that the 16, should they win or should there be negotiation, will be allowed to have additional licenses? Is that what's
I don't
increasing the
think that
number?
under this legislation, there'll be no negotiation. Under this legislation, and to make a correction, and this tells you what an issue we've dealt with this commission. There's 15 protests. There was one company that protested. And they sent their, as required by the commission, they emailed their protest. The commission says we didn't receive it, so tough. Well, you know, tough's an interesting word for bureaucrats. But when the appeal that they're showing the date time stamped on the email where it was emailed to them. And because of whatever reason, the commission didn't get it. So that 16th one, well, more than likely, if the commission doesn't evaluate that and determine whether if they did in fact send it on time, if they don't include that company, then that company will have another reason to file litigation. One against them, their failure to accept their protest, and then they can have right to another civil action. That's the reason we have said 22 maximum. Just quite frankly, do we fix it legislatively? It's not my choice, quite frankly. It's not my choice to put 22 companies out there. But I may be like our good friend, Mr. Jackson over here. At the time, we were talking about letting the fair market decide. But that wasn't the will of the General Assembly at that time. So the will of the General Assembly through the conference committee was at 6. We're going to 22. And we're going to 22 for one and one reason only. And that's to circumvent litigation that would tie this process down for possibly another 30, 36 months. So if you believe that there was validity, that medical cannabis oil could be a benefit to, quite frankly, some sick folks, that it might help them. That's what our purpose is here. And if you choose not to, hey, I can live with that. Anybody that wants to do that. But I tend to believe it is our duty here to finish the drill. The drill was started with hearings around the state. The legislation was done, but there was some flaws in between. I think that the conference committee that created some of them, I think it created some flaws. I think there were flaws in how they did this thing. When I read that part about them divvying up the application process, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. There's 10 of us on regulated industries here. That would almost be like a bill coming to this committee. And I appoint each one of you members to evaluate a separate section and tell you put a point system on that section, but I want you to know nothing about the rest of it, the overall bill itself. That's not the way it should have been handled. And if that's not the way, then maybe we can ferret out the folks over at the Cannabis Commission to give us an answer that they couldn't give in November because they said they were prohibited.
Chairman Carpenter.
Thank you, Chairman. This is more of a statement than a question, but I just, we all stood in the dome when we passed out this bill, and we were all excited about what we were going to do for the patients of Georgia, the kids of Georgia, the people that were sick in Georgia. And after 3 years of bureaucracy, we're still here, and they're no closer today than we were 3 years ago. So now, why I personally don't believe we need 22 licenses, I understand completely that this is the best way to get the product into the patient's hand. And that's what we passed because we know the importance of what we're doing. So I commend you for fighting the good fight. Obviously, I signed the bill. I believe in it, not because I want 22 people growing oil, making oil in the state of Georgia, but because I want the product in the patient's hands. So I thank you, Chairman.
Thank you.
Representative Williams.
Thank you, Mr. Chairman. Chairman Powell, I appreciate what you've done, and I've been right in that fight with you. We've got children that are sick and hurting all over this state. I've got one in my district, and talking to the families, how the seizures and how this has helped them live close to a normal life. We've got to do something. I applaud you through your many, many hours of hard work. And by George, I would like to get this resolved today so they can break ground tomorrow. Time is wasted. I've never been so fed up with government and coming from private business sector. When I decide to do something, we do it. Whatever it is, we make it happen. We need to make this happen now, today. And I appreciate you. I appreciate your leadership, and I appreciate you leading the fight. And I'm right there with you, brother, to fight for these people that are hurting and need this to make a difference in their life. Thank you, Mr. Chairman, and I appreciate you.
Thank you, Representative. And, don't give me credit. Listen, I occupied that chair. There's a reason that I occupy it, because we have to deal with a lot of issues. I'm pretty stubborn. I'm like yourself. There's some things that rankle me. Inefficiencies of government. But that's just like business. There's inefficiencies everywhere. This just happens to be one that fell through the cracks. And it needs to be dealt with. It needs to be repaired. And it's up to you, ladies and gentlemen, and it's up to the members of the full committee, and it's up to the members of the House. And if it gets that far, which I certainly hope it will, but I just want to leave you with one thought. As of today, there's 20,000 people who are on the cannabis registry. that have not been able to get this cannabis oil. So a lot of those people aren't even renewing, because these are the people that are having to go out of state. They're going somewhere else to get what they're going to get. Almost like a story that I told a few years ago about some folks in North Georgia. The reason that I was so emotionally involved, that I saw the grandchild of some friends of mine that lived up in a county above me. And this child was born with seizures, consistent seizures, to the point that this child had developmental disabilities and still does. But the only alternative for that family, and luckily they had some resources, but they took an apartment out in Colorado, and the mother would go and stay for a month or two with this child, then the father would go. Folks, that's not the way we do business of looking after people that need help. That child today is 10 years old, and that child weighs 30 pounds because of the disabilities of these seizures that they had constantly. Because it took a period of time before they realized that this oil is what controlled the seizures. Child doesn't have near the seizures, but the damage was done.
Representative Smith.
Thank you, Mr. Chairman. And this is more of a statement more than anything. If I'm not mistaken, we've created this mess. Now, I understand that we all want to do something, and we all understand that the time is now. But because of that same reasoning and rationale, we put forth legislation that's not working today. I am deeply concerned that we are rewarding people just because they have the ability to file a lawsuit.
I can't change the legal system. Jurisprudence is what it is. And you're correct. This was a piece of good intended issue in legislation that fell through the cracks. I don't know who to, I really don't know who to blame. Do I blame the commission for how they did it? Do I blame the legislature? Do I blame the budget writers that they obviously didn't get the money? Or did they even ask for money? I don't know, because they can't answer the question. But I don't think that anywhere in our minds that we knew that 3 years ago, what we passed put blinders on transparency. And there's nothing wrong with transparency in government so that the people, including legislators, can see what's going on.
Mr. Chairman, thank you. And I want to echo the comments of several members. I want to thank you, first of all, for holding the hearing we had when we asked the necessary questions about why we weren't getting something done here. And I also want to commend you for all your hard work and your efforts in putting forth a piece of legislation to do something about it. And I commend you for that. And thank you for doing this bill and for presenting it today. Ladies and gentlemen, we had a sign-up sheet. I don't think we had anybody to sign up, but if anybody would like to speak for or against the bill, we'll be glad to hear you. Thank you, Mr. Chairman.
Mr. Chairman, I've got a public utility meeting that I've got to get to present a bill. If you would remind the people here and on Zoom or whoever's watching that there'll be several meetings held on this starting tomorrow. Your subcommittee is, I think, scheduled from 3 to 5, and if necessary, more. But as the author of this bill and somebody who's worked on it, I would like to tell everybody within the sound of my voice, if you think there's another way of doing this, and I'm talking about seriously, to seek legal counsel, to keep this thing out of the courts so it moves forward. If they've got a better idea to do it, then please feel free to bring it up. And for all of those people, I'm hoping any and all people will sign up, not only for today, but for the meetings tomorrow and whatever other meetings are. And I want to thank you, ladies and gentlemen, for listening to me this afternoon. And I appreciate it and look forward to being with y'all again tomorrow.
Thank you, Chairman Powell. Who we had, please come to the podium and give us your name and make your comments, please.
Thank you, Mr. Chairman. I'll be brief. My name is Jacob Issa. I'm an attorney for one of the protesting groups, Windflower, Georgia, and I'll only speak on their behalf. But prior to that, I just want to the representatives that don't know me, I worked on this issue for about 7 years. I worked with Alan Peak early on, just as his aide and later on as a lobbyist. But to address some of the questions that I think we didn't cover completely in this, and specifically to the issues regarding litigation and regarding the number of licenses that were brought up. To my understanding in the bill, the reason that there are 19 class 2s potentially and up to 7 class 1s, there are companies applied for both license, right? Both a class 1 and a class 2. Under this bill, my understanding is that they would have the choice, the commission would have the choice as to which license they would receive since they applied for both. Since they paid the money, put the application for both, they should be able to have a chance at getting one or the other and not be cornered into just one. But with regard to the litigation, my fear is I don't want the committee to feel like this litigation was frivolous. The litigation had purpose. And the reason why is because many of these applications where millions of dollars were spent, right, were frivolously graded in many areas. In one section, as an example, the law had said for companies to come forward and show their ability to create jobs in tier 1 or tier 2 counties, impoverished counties. Now, for example, applicants like my client did so and showed their intent to create jobs in a tier 1 county, but were counted off half of the points in their application because the counties that surrounded the tier 1 county they chose to locate in were tier 2 and tier 3. Right. That is where the litigation came from. So I understand the concern that we're just licensing companies just because they protested. These were not just people throwing out money just to challenge the state. It was based on a real basis, real claims. And so I want the members of this committee to know that and to know that, a lot of these companies are not trying to take the state for a ride here. They have good intentions. They're well-organized companies. Many of them are majority minority owned. Many of them have Georgians that are majority ownership and are looking to just bring a good medicine that is needed in this state. So with that, I just wanted to mention that again. My name is Jacob East. I'm happy to answer any questions should anybody have any.
Thank you. I don't see any questions. Thank you for your comments. Who is next that wants to speak? Please identify yourself. And
Good afternoon. My name is John Paget. I'm the Chief Executive Officer of one of the protesting companies. And just got a couple of little comments. One is addressed to representatives that ask about why we're not letting anybody else into this process, I guess is the question right now. Those of us that have of the 50 or 60 companies that we're trying to get these licenses went into this process with our eyes open. We knew it was going to be hard to do and hard to accomplish what we were trying to accomplish. We got to the end and we didn't get it accomplished, but we followed almost all of the companies that I know, maybe all of them, followed the rules exactly. And that's what we're doing here. We're following the rules. If you wanted to get into this business, you had 2 years to decide whether or not you wanted to apply for a license. 60 companies or so applied. That's a lot. And then this process starts. And those of them that followed the rules are here in part of this legislation. And I encourage you to look at it and pass it and be proud of what you've done for the state of Georgia. It just bothers me no end at my age that I might not make it long enough to see this bill actually in fruition, and especially these children in this state that need this oil. And because of us, they can't have it. And there's just something wrong with us if we can't make accommodations to get this done. And I encourage you to do it. And by the way, I encourage you to go over here across the hall and talk to these folks because they don't have a clue about what this is about like you do. And they need some education. They need to understand what this is about and why and by the way, it makes no difference whether there's 12, 18, 20, 200, 400, 800 licenses. It doesn't make any difference. You're not going to make any more oil. You're only going to make enough oil to take care of the needs of those 20 or 30,000 or 40 or 50,000 folks that get a license from a doctor that say we can have this oil. Past that, there's no reason to make a hell of a lot more oil because we can't sell it outside the state of Georgia. So the number, if somebody, especially across the hall, says, well, we don't need that many. We had 6. Well, yeah, you do. You need that many to get through this bottleneck that we've got right here. So I encourage you to spend a little time over there and talking to them, because they're way behind the curve as far as it comes to what we're doing in here. Thank you, and God bless you. Any questions?
I don't see any questions. Thank you, sir. Next. Anyone? Yes, ma'am.
Good afternoon. My name is Dupree Yancey, and thank you so much for allowing me to speak. I'll make this short and sweet. I come before you today not as a lobbyist, but as a patient advocate. And I'd like to share an experience that happened to me last night with you, very relevant to all of this. Last night, my sister was admitted to Northside Hospital at 3:30 in the morning. She suffers from grand mal seizures. Although she was not born with epilepsy, she has become or was diagnosed with epilepsy due to undergoing several craniotomies. My sister is a registered patient of the Department of Public Health low THC oil program in Georgia. She does take pharmaceutical medicine for epilepsy, but she and our family and her doctors all agree that she gets greater alleviation of her chronic head pain from the high CBD, low THC oil, which is being discussed here. Due to her epilepsy, she cannot fly, she cannot drive. So she is very much at the mercy of this committee and this legislative process. And to clarify, she is currently in the hospital right now because of the inconsistency of finding safe and regulated product. We do not want her going out onto the streets of Atlanta to find unregulated product. That's just dangerous and that's not safe at all. So anyway, to wrap this up, in conclusion, I would like to gently remind you that while this legislative process continues, thousands of patients, just like my sister, are across the state of Georgia waiting desperately for the high CBD, low THC oil. Thank you. Any questions?
I see no questions. Thank you very much. Anyone else?
Greetings, member of the committee and state of Georgia. I am the Mr. Right Reverend Gregory Carl Davis, a corporation soul and a Georgia registered doctor of cannabis, which means that I have properly filed exemptions and am a provider of low THC oil. And I receive my recommendations of patients from Georgia licensed physicians that issue their cards. The cards given to the patients, and the patients ask, where do I acquire this? And there are a number of physicians that refer their patients to this ministry. And as a provider that began as a researcher in this medicine in 2008, number one, I can tell you that Canadian government has shown in their Canadian Health Department that warehouse grown cannabis or marijuana lacks efficacy in patient response. We hear this is a confounded legislation where you have both involvement of the pharmacy in outdoor grown cannabis through the university system. And we fail to hear what happened to the University of Georgia and what is it, Fort Valley State University. Now it's expanded to the other universities. The outdoor grown cannabis medicine is compliant in United Nations treaty obligations as outdoor grown cannabis in the same manner that coca and poppy is grown. There has been a change in the United Nations treaty obligation in that the Schedule 4, no medical use and drug of abuse, has been dropped from the United Nations treaty obligations under the drug conventions. Our state-sponsored research program, which requires chart monitoring and by the licensed physician, is compliant with United Nations treaty obligations. Warehouse grown cannabis is both outside of it doesn't comply with the United Nations treaty obligation. It's also a problem in conflict with federal law. Federal law has a botanical drug development where the cannabis or any medicine grown from plant material is under what's called botanical drug development, and the soil is required to be certified by the USDA. This bill is under the jurisdiction of the regulated industries. There was a mention by Chairman Powell of the Georgia Administrative Procedures Act, and my understanding is that medicine is regulated strictly by the Board of Pharmacy. There's another problem in this, in that you've got the Georgia Composite Medical Board's involvement as gathering data, and there's a what's called that's an unfunded mandate. The areas in the code where the Georgia Composite Medical Board, they disavow all jurisdiction. What I want to point out here, this legislation is, there's a confounding, we speak about God's medicine, and which I applaud. I'm glad you recognize the divine in this. And that's where this medicine's jurisdiction ultimately lies. And the litigation issue is that we are enforcing this through the criminal code. And so a patient that can't afford it, now the statement was made about the 20,000 patients, he left, they will all be able to have access to this medicine, faux medicine, under the regulated industries, which lack efficacy. This faux medicine will, they will have access if you got the money. What I've found in my treating these patients is so many of them, sick people, don't have money. And that's a burden for this ministry that I've done the best I could with. And the problem I have, and implore you to pay attention to the Spillers decision of Spillers versus the Georgia Court of Appeals in 1978, where the Georgia Court of Appeals gave an affirmative defense for the use of cannabis medicine in the future. It's the best way I can give you a thumbnail on that. And that we need to have a provision for homegrown cannabis medicine for poor people that can't afford it.
Well, thank you very much for your comments, and the committee has heard those, and we'll take that into consideration. Thank you. Anyone else? Okay, well, thank you all for being here, and we will stand adjourned without objection.